only card.
Each of the respective counts as detailed in the judgment delivered in this matter. I have considered the submissions made with regard to the issue of the accused person and the fourth accused person herein, and counsel for the second accused person, counsel for the third accused person, and counsel for the fifth and sixth accused persons hearing, and by the prosecution counsel. I have taken into account the mitigation made and perused the affidavits and documents filed and relied on during mitigation. Matters touching on merits of conviction were not open for canvassing at mitigation or pre-sentence stage, as the court does not sit on review of its own decisions at pre-sentence hearing or mitigation stage. I have also perused and taken note of the contents of the pre-sentence reports filed herein in respect of each of the convicts herein. Counsel for the prosecution and the defense made submissions with regard to whether which can be admitted in a case where a person has been convicted of offense of robbery with violence. I have gone through the authorities filed and also taken note of the decision by superior courts between the time the decision of the Supreme Court in the case of Murwatetu and another versus Republic, Katiba Institute and 5 others, reported in 22 Kenya Law Reports, that is decision on 14th December 2017, and the time when the Supreme Court made the clarification in Murwatetu and another versus Republic, Katiba Institute and 5 others, reported in 2021 KESC 31 Kenya Law Reports. That's a decision on 6th of July 2021. The Court of Appeal recently explained the position in the case of Miano versus Republic, and I read, the next question is whether the High Court erred in substituting the sentence of offense and found no merit in overturning it based on the Supreme Court guidance in Republic Fangi Institute for Strategic Litigation in Africa, ISLA, and 3 others. Petition E018 of 2023, 2024 KESC 34 Kenya Law Reports. The Court of Appeal further stated, and I quote, sentence severity if the sentence is legally provided for in the penal code. Also, this court has frequently, in explicit clarification in Murwatetu and another versus Republic, Katiba Institute and 5 others, 2021 KESE 31 Kenya Law Reports, that its earlier decision in Murwatetu and another versus Republic, Katiba Institute, 2017 KESC 2 Kenya Law Reports, only applies to mandatory death sentences for murder under sections 200 and automatically invalidate mandatory or minimum robbery with violence or sexual offenses. Accordingly, we are unable to interfere with the sentence of death passed by the High Court, which is provided under the law. End of quotes. The position of the law in that regard is well stated by the Court of Appeal, and that decision explains the position in Murwatetu on this court. There is no dispute that the convicts have been in custody during the entire period of the trial from the time of arrest. The court in sentencing is mandated under section 333 subsection 2 of the Criminal Procedure Code to take into account the period of time spent in custody. This section should therefore apply to determinate sentences. The period of time spent in custody shall therefore be taken into consideration. I have gone through and taken note of the mitigations made in relation to each of the convicts herein. A plea for leniency has been made in respect of each, and each has expressed remorse. The prosecution has not proved in the manner required the existence of any previous conviction in relation to any of the convicts herein, and therefore each of the convicts herein shall be treated in this sentencing as first offenders. I have also taken into account the nature of the offenses of which the respective convicts have been convicted and the sentences provided for the same. I have also taken into account age of each of the convicts herein and their personal circumstances as reflected in the pre-sentence reports filed. I have also taken into account the circumstances under which the offenses were committed, and for the robberies, the fact that the victims who were PW1, PW3, and PW4 were abducted in the course of the robberies which were committed on the material night. The first victim having been carjacked and robbed, and his vehicle used to access the second set of victims by the same robbers who carjacked, abducted, robbed the second set of victims, that is PW3 and PW4, before being abandoned that night. While the first, second, and third, and fourth convicts have indicated remorse, the offenses are very serious, and the victims also deserve justice. The offenses were committed with utmost impunity, armed with rifle previously robbed from a police officer. The circumstances in which the robberies were committed call for the sentences provided for at Section 296(2) of the Penal Code. The decision of the Court of Appeal in the aforesaid Miano case, a decision made on 25th of March 2026, is clear on the position of the law with regard to the sentence provided for under Section 296, subsection 2 of the Penal Code. Decisions of the High Court So the decisions of the Court of Appeal take precedence over decisions of the High Court. I consider the following sentences reasonable and appropriate. A, count numbers 1, 2, and 3, each of the first, second, third, and fourth accused persons or convict is sentenced to death as by law provided on each of the said counts numbers 1, 2, and 3. However, as by law required, execution of the sentences on counts numbers 2 and 3 shall be held in abeyance because the sentence on the first count renders the same sentence on the other counts with regard to the same convicts moribund. B, on counts numbers 4 and 5, which relate to the first and sixth accused persons only, each of the first and sixth accused persons is sentenced to 10 years imprisonment with effect from the date of first committal to remand custody. C, on counts numbers 6 and 7, which relate to the second accused person only, the second accused is sentenced to 10 years imprisonment from the date of first committal to remand custody. On count number 8, which is against the fifth accused person only, the fifth accused is sentenced to 10 years imprisonment with effect from the date of first committal to remand custody. Sentences imposed on counts 4, 5, 6, 7, and 8 shall run concurrently for the respective convicts. Also, execution of sentences in respect of counts 4 and 5 for the first accused person, and in respect of counts 6 and 7 for the second accused person, shall be held in abeyance in view of the sentence imposed in respect of the first 3 counts. Firearms and ammunition produced in the course of this trial shall be forfeited to the state. However, since there is a related murder trial still ongoing before the High Court against the first to the fourth accused persons, the order for forfeiture shall take effect only upon conclusion of that trial. Any party to the case who is not satisfied with the conviction or otherwise in relation to the person who was the seventh accused, or any of the sentences or both, has the right to appeal within 14 days from the date hereof. Typing of proceedings be done and the same be supplied to the convicts or their counsel upon receipt of the formal request to the registry in the normal manner. Orders accordingly. The sentence is typed. It shall be uploaded to the portal within the next 5 minutes. So the council on record will be able to get their copies online. So I think that marks the end, and thank you. Thank you.
Petri kutoka back. Petri ya hii kamera. Kimbia. Tunapiga picha. Anataka kuongea.
Today the court has pronounced itself on our client, that is Raphael Kimani, the second convict, and the court has sentenced him to the sentence of death as provided for under the statutes in section 295 and 296. We are not satisfied with the decision of the court. We shall be moving to the High Court to challenge that decision. It looks a tall order, but I'll give a chronology why this is not a tall order. You can see the mother of Raphael is present. All the mitigations that we did, nobody took interest of those mitigations. It was academic. There was no need to put the convicts to mitigation, to look for the probation officers to do a pre-sentence report. When move one step backward. But this is not new. Previously, only one sentence, death, until Senior Counsel Fred Ngatia took up the matter and took the angle of how constitutional the sentence is. The matter moved from the magistrate's court to the High Court, to the Court of Appeal, to the Supreme Court. Muruatetu 1 made murder, convict of murder, can be jailed for 1 day, jailed for 1 year. A comparative approach towards a robbery with violence where nobody has lost life compared to where somebody has lost life. A killer goes home with 2 years or 3 months or 1 day. But robbery with violence is death sentence. We are determined to move to the Supreme Court for that to be determined. Remember, we are aware 3 judges declared the offense of robbery with violence as unconstitutional. The decision, we are awaiting the judgment over that question. The implementation of the offense of robbery with violence, which is an illegal sentence. It is an illegal because the ingredients of robbery with violence are vague, are ambiguous. But the judge, the magistrate, has pronounced himself. We respect the decision of the magistrate, but we do not agree with the findings of the court. We shall be moving to set precedent so that mitigation does not only apply to people who have committed murder. Article 27, equality of the law. Offenses are the same. Why should murder convicts be treated with kid gloves, while convicts of robbery are not given the same preferences? So we shall be coaching our petition in a constitutional manner that this is discriminatory because others are granted that. Remember, Murwatetu 2 was a decision where nobody moved the Supreme Court. The Supreme Court moved by itself the concept of suo motu and provided guidelines that Murwatetu 1 only applies to murder. So now we are going to beckon on the door of the Supreme Court on Raphael Kimanzi, which the Supreme Court must deal with. The Supreme Court cannot make a specific law to deal only with a specific offense. All criminals or offenders are the same in the eyes of the law. And that is what Article 27 provides for. The limitations provided under Article 24 cannot be limitations only for robbery with violence victims, again excluding the murder suspects. We are appealing to the family to be firm. The journey will be long, but we are determined that Raphael Kimani one day will see the outcome and take this bright sunlight that the lawyers and the family and the media are enjoying. Asante.
Yeah.